right, thank you everyone for joining us for today's presentation on mandamus lawsuits. My name is Dustin Saldarriaga, and I'm a senior associate with Scott Legal PC. Our webinars are part of a series. We try to do at least 2 a week, and these do cover a range of topics regarding U.S. immigration law. So we do hope that you will join us for future webinars. After this webinar, we will be sending you an email where you can see a link to sign up for our future webinars, as well as a link to our YouTube channel. We are recording this presentation, and we do post our full-length webinars to our YouTube channel. Our email will also have a link to our blog, where we're proud to post a significant amount of information, again, covering the full spectrum of U.S. immigration law for free, and we hope that's helpful to you. Our firm, though we do focus on U.S. business immigration law, we do handle the full spectrum of U.S. immigration, whether that is family-based immigration, temporary visas, student visas, visitor visas, as well as what we'll be talking about today, litigation. So regardless of what your question or issue is concerning, as long as it's related to U.S. immigration, we do hope that you'll reach out to us for assistance. A few housekeeping items. If you do have a question during the presentation, feel free to send it to me through either the chat box or the Q&A box on Zoom. I will be monitoring both. And though I plan to save the questions for the end, I do plan to get through all of them by the end of the presentation. So don't hesitate to send those in to me. All right, without further ado, excuse me, let's go ahead and talk about mandamus lawsuits. So mandamus is not a common word that we use, but what mandamus is a type of lawsuit where you are requiring the government to perform some kind of action that it's required to do. So this is a lawsuit where, in the context of immigration, say, you've filed an application with the government, you've paid the filing fee, you've done everything that you are supposed to do, and the government is not doing anything. So this is a lawsuit that is, in that context, asking a federal judge to tell the U.S. government to do their job, saying, we filed the petition, we have paid the filing fees, we've done everything we're required to do. Now the ball is in the government's court, Your Honor, and we are asking you to make the government now do its job. So one thing that's very important to know about mandamus lawsuits is that you do not file a mandamus lawsuit to request a certain decision. You're not asking the judge to tell the government to approve your application. You are only asking the judge to tell the government to decide your application. So you're just asking them to do their job. So the decision could be an approval, it could be a denial, or it could be a request for additional information. So that's important to keep in mind. A mandamus lawsuit is only asking the government to do its job and to reach a decision, not to reach a specific decision. You're not asking the judge for an approval. There are lawsuits, so if you are denied, then there are lawsuits to challenge the denial, but those are not mandamus lawsuits. Mandamus lawsuits are simply asking the government to do its job. A mandamus lawsuit can be filed against, really in the context of immigration, any U.S. agency that may be responsible for the delay. So that could be U.S. Citizenship and Immigration Services, or USCIS, could be a consulate, or it could be another government entity that has a responsibility to act. That could be the FBI, for example, if they need to perform a security check. And mandamus actions can be used to compel the government, to make the government decide a variety of applications. So if your immigration petition is delayed, if your temporary visa is delayed, whether that is at a consulate or if you've applied for a change of status in the US, if you've applied for work authorization and that has been delayed an unreasonable period of time, all of these could be suitable for a mandamus lawsuit. Now, while mandamus lawsuits tend to look very similar, this presentation is going to focus on EB-5 applications. And the reason for that is EB-5 applications do tend to be those that our firm focuses on in the context of litigation. EB-5 applications do also tend to be somewhat complex, and they raise very interesting questions about these lawsuits and aspects of these lawsuits and how to argue them, what arguments the government tends to make on them. So EB-5 applications do make for good subject matter when discussing mandamus lawsuits in general. And when I say mandamus lawsuits look similar, I'm talking about broadly the process, and we'll talk about that process later in the presentation, as well as the arguments we make and the arguments that the government tends to make in response. So even though we are focusing on EB-5, that'll be kind of the example that I use. What I'll be talking about is broadly applicable to mandamus lawsuits, regardless of whether the lawsuit is an EB-5 petition that's delayed, work authorization that's delayed, a U visa that's delayed, whatever it is. And I'm sorry if I have to keep clearing my throat. I've been sick lately. So let's talk about what makes a strong mandamus case. And another way to frame this is, how long do you need to be waiting before you should really be seriously considering filing a lawsuit? Because filing a lawsuit is not a small matter. It's not a small matter in terms of the expense. It's not cheap to file a mandamus lawsuit. Our firm charges hourly for these lawsuits, and it does take some time. It takes time to prepare the complaint, which is the first step in filing the lawsuit. It takes time to wait for the government to respond. It takes time for the judge to reach their decision. So it is a big decision when you're deciding whether to actually file a lawsuit on a case. So the first thing, if you were to reach out to us and say, I've been waiting for this application to be decided, is it time to file a lawsuit? The first thing we would really consider is the delay, the government's delay, unreasonable? And the first thing to look at when deciding whether a delay is unreasonable is usually the government's published processing time. So the first thing we would do is to go to USCIS's website, and we would look at what USCIS estimates is a reasonable amount of time to wait for an application to be decided. So to take the example of an EB-5 application, USCIS estimates that the first step of an EB-5 application, which is the I-526 form, could take about 5 years. So in general, if you have been waiting, given that 5-year estimated processing time from USCIS, if you've been waiting 6 years for your application to be filed, that would certainly in our minds be unreasonable, because you are waiting even longer than USCIS estimates you should be waiting. And fortunately, if you have been waiting longer than USCIS's processing times, what we find is that often USCIS will settle, which means that we'll file the lawsuit and USCIS will say, you know what, this is outside our processing times. We will go ahead and prioritize deciding this application, which means that the judge doesn't have to reach a decision. It means that there's not a whole lot of back and forth. It can actually be a quite fast resolution. It could happen within a month or two of filing the lawsuit. Unfortunately, in most cases, USCIS's processing times are beyond what what the person has been waiting. So going back to the EB-5, USCIS estimates it should take them 5 years on the application, which we think is absurd. We think that estimate is unreasonable. So someone will come to us after waiting 3 years or 4 years, maybe 2 years on their application. So we'll see you've been waiting 2 years, 3 years. USCIS says it'll take longer. So basically, we enter the next stage of considering whether the delay is unreasonable, which is to discuss what that delay has caused in the life of the applicant. So is the delay, for example, keeping you from being united with your family? Is it causing issues when you're applying for a driver's license, when you're applying for school, when you're trying to work in the United States, when you're trying to even register to vote, depending on what application you're talking about being delayed? So the harm that's caused by the delay is very important and would play an important role in the lawsuit. So that's kind of another factor we would consider when determining whether a delay is unreasonable. We would also talk with the person about what other steps they've taken to try to push the application forward. So have they reached out to USCIS? Have they reached out to the ombudsman to complain about the delay and ask the ombudsman to look into it? The reason why these steps are important, this is called exhausting administrative options. So the administrative options are those provided by USCIS, provided by the Department of Homeland Security, by the Department of State. Many judges will want to see that you've taken all the steps you can before you reach out to a court to resolve these issues. So you do want to make sure that you've taken all those steps. And many of our clients haven't done that before they reach out to us. So we will actually help them take those steps before we actually file the lawsuit. So even if you have taken all these steps, and even if you've waited and USCIS says that the processing times are longer than you've waited, we would still continue looking at the situation to determine whether it is reasonable. One of the things we would do is to look at any information, any publications, any public statements that the government has made that shed light on how long these applications actually do take. And this is separate from what their estimated processing times are. Just to give an example, the government, Department of Homeland Security, when they issue a notice of proposed rulemaking, so when they are planning to change their rules or regulations, they oftentimes will need to disclose to the public certain aspects of their procedures that justify the changes of the rules. And one of the things that they will oftentimes disclose is the number of hours that it takes an employee of the Department of Homeland Security to decide any number of applications. So an I-526 form or an I-485 form for a green card, an adjustment of status. And you'll actually see in those published facts, that data, that a form that USCIS says will take months or years actually takes an employee a handful of hours. It could be 8 hours that it takes the employee to decide the application. That's an example where we would look at that and we would say, you know what? The 5-year processing time we don't think is reasonable because we now know it takes them 8 hours to decide the application. You can also look at other factors. So, for example, there may be information on the government's employment practices. Maybe they have cut jobs. Maybe they have made statements saying that it is their priority to expedite these applications. And even while saying that, the amount of time it's taking them is increasing and the number of applications they're seeing is decreasing. So you can find this data, you can find these public statements. This is really what we do as we make the determination as to whether the government's delay is reasonable. And at the same time, thinking about what arguments we will make in the lawsuit should the client decide to move forward. And finally, one of the important things to look at is, has Congress actually passed a law that says that they think these applications should be decided in a certain period of time? And fortunately, oftentimes Congress does when they're passing a law regarding a certain visa type or even general operations. They may state, we expect that an application will take no longer than, it could be 60 days, 90 days, something along those lines. So we would also look at any indication from Congress that suggests whether a delay is unreasonable. So if we take a look, we say, yes, We do think that the delay has been unreasonable. It's not binary. So what it is even if you've only been waiting a few months, and USCIS says, say, an application should take 5 years, excuse me, that's not to say that we would not file the lawsuit necessarily. Again, if it's caused you harm, if it's caused your family harm, there may very well be a good argument to make. But the important thing to keep in mind is that the shorter the delay, especially compared to estimated processing times by Homeland Security, USCIS, Department of State, the shorter the delay, the more likely it is that the government is going to oppose our complaint, which is usually in the form of a motion to dismiss, which we would have to respond to and possibly argue in front of the judge. And the more likely that the judge will agree with the government. So just to take an example, on an EB-5 application, if the government is saying it takes 5 years, you've been waiting 6 months or even a year or 2 years, that is considered a relatively short amount of time to wait. So it is likely that the government will file a motion to dismiss in that case. And based on current case law, and it does depend on which circuit you're in, and we would do that research, but in general, judges do tend to side with the government if the wait on EB-5 applications, I'm talking about the I-526, is 2 years or shorter. So you need to be aware that if you've been waiting a shorter period of time and you do decide to move forward, it could be a time-consuming process, it could be an expensive process, and at the end of the road, it's possible that the judge would not agree with us and would decide the government gets more time on this application. So you really do need to balance, is it worth waiting longer if that means strengthening my lawsuit? And we may say, you know, our recommendation is wait another year, wait another 2 years, see if the application is decided. And at that point, we would have a stronger case. It may be more worthwhile for you to spend the time and money to go through litigation. So returning to our slide, what is the mandamus process? I already mentioned before, one of the preliminary steps is exhausting administrative remedies or options. That means really using any of the channels that, say, USCIS makes available to you to inquire about the status of your application, going to the ombudsman, asking them to look into the delay and to resolve it if they can. If you've done that and it has not resolved the issue, which is typical, that those steps usually don't resolve the issue, then after you've spoken with us, we've talked through the costs and benefits of litigation based on how long you've been waiting. If you decide to move forward, we would draft what is called the complaint. A complaint is what starts a lawsuit, and it basically lays out who you are, who the defendants are, which would be the government, the facts of the case, how long you've been waiting, what you applied for, how much the filing fee was. We would get into any harm you have experienced based on the delay. We would get into the facts that I mentioned before about how long the government says it will take versus how many hours it actually does take based on government disclosures. We would go into potentially government statements on their priorities, their process, whether their process is reasonable based on what we know about how they decide how to work through the line of applicants. We would get into all those facts in the complaint. It would be a very robust document, very well drafted, because if the government does oppose the lawsuit, the scope of the arguments are going to be that complaint. So the complaint is going to define really all the issues we're arguing about, and it's going to allege all of the facts that we're going to rely on in the lawsuit. And when the government opposes that complaint, they are really supposed to limit their response to the arguments we've made. And then when we respond to the government, we are going to go back to the complaint, use those allegations, those facts in the complaint, and to form a strong response to the government's motion if they do decide to oppose the complaint. Excuse me. Once the complaint is filed with the court, the court will issue summons, which is what basically tells the government we would be responsible for serving that on the government, and it tells them that there's been a lawsuit filed. Once they are given notice that a lawsuit has been filed, they have 60 days to respond to the lawsuit. So typically, nothing is really going to happen in those first 60 days. What is happening in the background is that the case is assigned to an assistant U.S. attorney, which is a lawyer who works for the U.S. Department of Justice. The U.S. Department of Justice will represent U.S. Citizenship and Immigration Services or the Department of State, whichever agency it is that you've sued. Typically, the DOJ, Department of Justice, will represent them. It'll be assigned to a local U.S. Attorney's office, and at the U.S. Attorney's office will be assigned to an assistant U.S. attorney. And that assistant U.S. attorney is one of the first things they're probably going to do is call the agency. So they're going to call USCIS or the Department of State, and they're going to say, what's the status of this application? Are you guys about to decide this, or is there a huge line ahead of you, ahead of this application? So they're going to get a sense of where the application is. They usually don't do that until the end of the 60-day period. So it's important to not expect that you file a lawsuit and everyone in the government is rushing to respond to the lawsuit. That's not how it works. Usually it's assigned to an assistant U.S. attorney, sits on their desk, excuse me, for a few weeks. And when that 60-day period is close to coming to a close, the assistant U.S. attorney will call the government agency, find out where the case is, and they'll usually reach out to us for an extension, which we will usually agree to. And the reason is, it is very important when there are reasonable requests made in litigation to agree to those, because they do go both ways. Sometimes we will need accommodations, and you really do want to show the judge that you really are trying to work with the other side to resolve this issue. So, as you can tell, though, it is important for USCIS or the Department of State, the consulate, to get a phone call from an assistant U.S. attorney who tells them a lawsuit has been filed on this case. So what's the status? Even that simple step could motivate the agency to say, to turn their attention to your application. So resolution of these lawsuits does happen, and I call that settlement. If the case is just stuck and no one has been paying attention to it, then sometimes it could get the case unstuck for an assistant U.S. attorney to pick up the phone and call and say, hey, there's a judge looking at this. What's the status? And is there any way to resolve this so we don't have to spend hours going to court and filing papers with a judge? So that can be a very powerful thing. Essentially, a lawsuit, filing a mandamus lawsuit, assigns an assistant U.S. attorney to kind of push your case forward in some ways. Now, that doesn't always happen, and especially in the current administration, and as delays grow longer and longer, what we find is that agencies do tend to tell the assistant U.S. attorney, we're not going to give this application any additional attention. They're just going to have to keep waiting. We want you, attorney, to argue, to go to court and oppose this mandamus, excuse me, lawsuit. And so we do find that the government does tend to fight these more and more as time goes on. So be aware of that. But that being said, these lawsuits do have we certainly have a success rate on these lawsuits, and we do see that they are one of the more effective ways to push a case forward. So I've been talking about settlement. If the government does tell the assistant U.S. attorney, we're not going to settle this, we want you to fight this, that means that the government will litigate. So if the government does litigate, usually the first thing they will do after the 60 days has passed, they've asked us for an extension, which we typically will agree to. If they want to litigate, their next step is probably going to be to file a motion to dismiss. And what a motion to dismiss is it basically tells the judge, Your Honor, assuming that everything that the plaintiff, which is us, which is you, the plaintiff has alleged, assuming that everything they've alleged is true, they still don't have a case. So a motion to dismiss is actually quite a high bar for the government to meet. And so we spend a lot of time responding to the motion to dismiss, really to convince the judge that if you do take all of our allegations as true, we actually have made not only a viable case, but a very strong case. And we have been successful on those motions. Of course, past performance doesn't predict or guarantee the future, but our track record has been a good one on motions to dismiss. And a lot of that is we spend the time doing the research to try to understand the government's process and whether it even has a process. And oftentimes they don't. We look for exceptions to their procedures that show that they don't actually adhere to their public statements on what their process is. And we find that by doing that and by emphasizing the harm that our clients face from these delays, judges do tend to be understanding. Judges are humans. So if you do lay out the facts clearly and in a compelling way, especially harm, judges do tend to be receptive to that. So I'm sorry. Regarding the motion to dismiss, if the judge does agree with us, they would deny the motion to dismiss, deny the government's motion to dismiss, and they would say, I'm going to allow this lawsuit to move forward. At that point, we would make it clear to the government that we do want to engage in discovery, which means we want the government to really disclose documents that explain its process, documents that show the line of applicants, where our client is, and whether their application is actually being delayed. And the fact is that the government almost never wants to disclose that information. And so they will, at that point, typically settle. If the judge denies the motion to dismiss, then a settlement almost always comes very quickly after that. Settlement, again, meaning the government will say, okay, we'll get you a decision within a certain period of time, and we'll negotiate that period of time. It usually is in the realm of about 60 days for the government to issue a decision. If the judge does decide to grant the motion to dismiss, then of course that the case is dismissed at that point. So that does come down to the judge's decision. Mandamus lawsuits almost never end up in front of a judge where both sides are arguing the merits of the case, and they've conducted discovery, which is where they get documents, they get to do depositions. These cases almost never go to that stage. And again, part of that is because the government does not want to engage in discovery. They don't want to disclose documents. They don't want their employees to be deposed. So they will settle before we get to that point. So I've already touched on this slide, what's in this slide, but the government's response to the complaint is typically either settle, and that will happen if the agency says, you know what, we're about to get to this decision, or if the attorney says, look, I don't think the arguments on our side are strong, the government attorney. We're outside the processing times. Is there any way for you to decide this? Sometimes the agency will say, yes, we can go ahead and decide this, and it results in settlement, where we will execute basically an agreement with the government that says in 60 days, typically 60 days, they will issue a decision. If the government decides to fight or litigate, they will file typically a motion to dismiss. And if the motion to dismiss is denied, and we do get to engage in discovery, then sometimes it will go to a motion for summary judgment. And a motion for summary judgment really does ask the judge to reach a decision based on all the facts. So you will be able to make arguments based on the documents, based on the depositions. But again, these cases typically don't go to a motion for summary judgment. Let's talk about some common questions in mandamus cases. Can I file a mandamus action or lawsuit to compel the government to approve my petition? The answer to that is no. Again, mandamus cases are asking a judge to tell the government to reach a decision, not to reach a particular decision. So as long as the government does reach a decision within the agreed upon time, that resolves the case. So even if the judge says, okay, within 60 days, I want you, government, to reach a decision, that decision could be a denial. And even if it is a denial, that resolves the mandamus lawsuit because there has been a resolution to the application. Now, if you get a denial and you think it's unreasonable, you can file a separate type of lawsuit to challenge that denial. So I'm not saying there is not a remedy there. I'm not saying there's not a lawsuit. There's just not a mandamus lawsuit. A mandamus lawsuit is when you're facing a delay, there has not been a decision, and you're asking a judge to tell the government to reach a decision. So how much time must pass before a delay is considered unreasonable? Again, a mandamus lawsuit is a reasonable response when the delay has been unreasonable. So how do you know it's been unreasonable? Again, there are a number of factors that go into that. Step one is looking at the government's published processing times. If you've been waiting longer than the published processing times, then essentially by definition, the delay is unreasonable and you would be justified in filing a lawsuit. Your odds of settling favorably are definitely higher if you are outside of the government's processing times. Some of the other factors we look at are, again, the harm you've faced as a result of the delay. Again, even if you're within the published processing times, if it's really creating a hardship for you and your family, you may still have a viable mandamus lawsuit. We would also, again, dig into the facts, dig into statistics, dig into congressional publications, disclosures made by the agencies to see if the amount of time it takes the agency to decide these cases justifies the delay. So we would get into those facts. And all of that goes into, at the end of the day, whether we think that a judge could be convinced that this delay is unreasonable. At the end of the day, we always do have to keep the judge in mind because the decision ultimately does rest with the judge. How long does it take for a mandamus action to be decided? So again, you file the complaint. The government has 60 days to even respond to the complaint, and they are usually going to ask for an extension, and that extension could be another 30 days or so. So usually you file the lawsuit, you're not going to have much motion at all, typically within the first 2 to 3 months. Sometimes, if it is clear that you're outside the processing times, sometimes the government will settle in that time. So it is possible for there to be a resolution in the first 2 or 3 months, but typically the government is not going to make an offer to settle in that time frame. They are having a discussion internally between the attorneys and the agency to decide where the application is and what the next step should be. After that initial 2 to 3 month period, oftentimes what will happen is the government will file a motion to dismiss. When that happens, it's going to take another couple months or so for both sides to file their arguments with the court. And then it can take the court months to decide the motion to dismiss. It could be 6 months, it could be 9 months, could be shorter, but oftentimes what we see is about 6 months. So at that point, you really are looking at 9 months to a year before the court is even issuing a decision on the motion to dismiss. So you can see how these cases do take a significant amount of time. It's not the kind of thing where you file the lawsuit and the government drops everything to respond to it. This does take time. So it could be a year, possibly even longer, before you really have a decision from the court, at least on the motion to dismiss. I'm sorry, excuse me. So one common question is regarding retaliation. If I sue the US government, what is keeping them from just denying my application or retaliating against me? Um, you know, using this against me if I apply for a future benefit. And really all we can say in response to that is that we essentially never see that happen. It's important to keep in mind a few things. First of all, the government tends not to have uh, good coordination between the agencies where they can deliberately coordinate a retaliation effort. That's not to say they can't do it. It's just to say that it's not really the way the government works. So that's the first point, is the government is not typically coordinated enough to retaliate. The second thing is retaliation is serious. The government could get in trouble for doing it. They are certainly not supposed to do it. And the third point is we just don't really see that happen in practice. We don't see the government retaliating. What we do see is we engage with the government's attorneys, we file papers with the court, our motions with the court. The judge decides, and then the government just does its job. That's usually what we see. That's not to say that they won't issue a request for evidence. They oftentimes will. Um, but in our experience, the government is fair in their decisions, and the decisions they reach do seem to be what they would reach regardless of whether a lawsuit was filed. The last point I'll make is as delays become longer and longer, the government appears to be thinking about mandamus lawsuits as just the way to request an expedite. And it is sad. That's a sad reality because it is basically saying that if you have compelling circumstances that warrant an expedite request, you essentially have to um, you essentially have to pay the cost of hiring a lawyer and filing a lawsuit with the government. But our understanding is that the government has come to expect these lawsuits because their delays are growing so extensive. Um, so, the government is not receiving a lawsuit and saying, oh, I'm taking this personally. We're going to do something to get back at these guys. They get a lawsuit and it's just part of their job. Um, the next question, my application is delayed at a US consulate. Can I file a mandamus action against the consulate? You can. Um, you can sue a consulate for a delay. This is not, you're not challenging a decision. Again, a mandamus lawsuit is asking the consulate to reach a decision. Consulates are protected if they have reached a decision and you're trying to challenge that decision. If they've denied your application and you're trying to challenge that denial, those lawsuits are very difficult. They tend to fall within something called consular non-reviewability, which means that courts are reluctant to look at why a consulate denied an application. But we're not talking about a denial here. We are simply talking about a consulate reaching a decision. And when that's the case, you can certainly file a mandamus lawsuit against a consulate. Should I work with a lawyer if I decide to file a mandamus action against the government? We would certainly say yes. These are these tend to be complicated, time consuming. This is litigation, so you need to know how to file a lawsuit, how to prepare a strong lawsuit and complaint, how to engage with the government so that you're trying to settle at the same time that you're trying to show the court you have a strong case. So these are not simple matters. These do tend to benefit quite a bit from having an experienced attorney moving the lawsuit forward. With that, I will turn it to questions. I don't think we've received any questions during the presentation. If there are any last minute questions, please do feel free to send those in. And in the meantime, I'll just say, do keep an eye out for our email with a link to future webinars, this PowerPoint presentation, our YouTube channel, our blog. Sign up for future webinars. We do hope to see you on those. And if you have any questions or wish to discuss your delays, your petitions delays, do schedule a consultation. We'd be happy to talk with you about that. So thank you so much for taking the time. It's been a pleasure speaking with you all. Stay well. We hope to see you on future webinars.